First of all, Abdul, allow me to at least announce the beginning of session 3.
Please do.
To welcome everyone who is participating in session 3. There are at least 31 participants at the moment, so we welcome all of them. My name is Rick Lofczewski. I'm going to chair the session. I'm from the University of Hong Kong. I'll introduce now the first speaker by name. In fact, he has a team of co-presenters listed, but he will present alone today, and that is Dr. Abdul Majid from Monash University, Malaysia. And the title of his presentation is, Does the Malaysian Law of Equity Permit an Apology as a Remedy for Defamation? Abdul, take it away.
Okay, thank you. All right, I will share screen first. Can you see the screen?
Yes.
Okay. Okay, I have to begin with an apology and a correction. The apology is because I need to correct the title of the paper. The paper is actually, does the law of equity in Malaysia and Hong Kong permit the apology as a remedy for defamation? So it covers 2 jurisdictions. Okay. Okay. All right. I start the paper from the time of the Courts of Judicature Act 1873 in UK. Just before 1873, England had many high courts, each exercising either common law or equitable jurisdiction, and just as many courts of appeal, each exercising just common law or equitable jurisdiction. The dual system of courts, of jurisdictions, placed the courts in silos. So there seems to have been very little transfer from one to the other. Now, then the English judicial system was overhauled by the Courts of Judicature Act 1873. By Section 16 of the Act, or Section 16 of the Act, abolished the many high courts at common law and equity and replaced them with a single high court, to which it transferred the jurisdiction of the abolished high courts. This had the result of making the high court both a common law and vested the high court with both a common law and an equitable jurisdiction. Section 18 did the same thing to the courts of equity. It abolished all the many courts of equity and created a single court of equity. And it transferred the jurisdiction of the high courts of equity and the high courts at law to this one court of appeal. So the court of appeal also had, also was vested with both equitable and common law jurisdiction. Now we continue with that. Section 25 sub 11 of the Courts of Judicature Act then provided that in the event of a conflict between the common law and the rules of equity, the latter was to prevail. These 3 sections of the CJA, the Judicature Act, define what has come to be called the judicature jurisdiction. So in the common law world, whenever we have the equivalent of these 3 sections in the law of the common law jurisdiction, it's known as a judicature jurisdiction. Okay. Now in Malaysia, the judicature jurisdiction is embodied in the Civil Law Act 1956. And specifically in Section 3, which provides for the application of the UK common law, the rules of equity, and certain statutes. I'm not going to read this because this is just statutory. And in Hong Kong, the judicature jurisdiction is created by virtue of Section 16 of the High Court Ordinance. This is to be found in sub 1 of Section 16. I don't have to quote it, but I also have Section sub 2 and sub 3, they don't need to detain us. So this is the judicature jurisdiction that was transferred. Now, one of the equitable remedies, as we all know, is the injunction. An injunction may be prohibitory or it may be mandatory. I don't think I have to explain what the difference between the 2 is. Historically, as the law of defamation developed at the common law, it provided solely the remedy of damages. This did not, however, prevent the common law from drawing before or after the Court of Judicature Act 1873 on the equitable remedy of the injunction to prohibit the repetition of defamatory statements. The injunction was used, as it still is, to serve the ends of justice by prohibiting unlawful behavior. The CJA 1873, by vesting all courts with equitable jurisdiction, empowered them to draw on equitable remedies to respond to the demands of justice. The fact is that in England and in other judicature jurisdictions, the courts, as courts of equity, deal with applications for both prohibitory and more rarely mandatory injunctions. Now, it's our submission, I think we're not wrong in this, is that an apology ordered by a court, I refer to that as apology order. If it is not a mandatory injunction, it is at the very least akin to a mandatory injunction. The judicature jurisdiction created by the CJA 1873 permits the courts to do this when they have the equivalent of that. Now, that is the background, and that's the where we stand. Now, I don't want to give the impression that the apology is unknown in the defamation cases. The fact is that the English codified their, embodied maybe more accurately, their defamation provisions in the Defamation Act 1952. And Hong Kong and Malaysia then incorporated this in their own statutory form. In Hong Kong, we have the Defamation Ordinance Chapter 21, and in Malaysia, we have the Defamation Act 1957. Okay. These reproduce or resemble provisions of the UK Defamation Act 1952, and sometimes they even go further back to the Libel Act 1841. Just to update ourselves, the UK enacted the Defamation Act 1996 and the Defamation Act 2013 to amend and update the law of defamation as contained in the 1952 statute. Malaysia has taken no such steps, and as far as I'm aware, neither has Hong Kong. So from that, I proceed from there to apology. Now, the next 4 or 5, 6 slides say things about defamation and apology in the two jurisdictions, which should be common to us, but I'm just going to run through this to refer to them. Both statutes, both the Hong Kong and the Malaysian statutes, provide for an apology in mitigation for defamation. In the Defamation Ordinance, this is found in Section 3 and 4, and in Malaysia, the equivalent provision is Section 10, 1 and sub 2. Then both statutes provide for an apology to make amends for unintentional defamation. Okay. This in Hong Kong is found in the ordinance at Section 25 and in Malaysia in Section 7. Okay. Whatever it be, the position of the apology is the same in Malaysia and in Hong Kong, because in both jurisdictions, there are enough common law decisions to say that if an apology is tendered, then damages can be mitigated, damages are reduced. So in Hong Kong and in Malaysia, we have express statements by judges that the earlier the apology is offered, the greater the discount in damages. Now, I have a number of cases here from Malaysia. I'm not going to take you through them, but they simply make the point that I have just made in Hong Kong and Malaysia. From Hong Kong, I have a quotation from the decision of Madam Justice Lee Pichon. She then was in Hong Yung Chan Robert and Hong Kong Standard Newspaper and others, 1996. There, her ladyship observed, the objective of damages is to restore the plaintiff as so far as money can do so to the position you have been in if the tort had not been committed. She then tells us to see Duncan and Neil on defamation, where there's been no retraction and apology, and order for damages is the only solitium available to the plaintiff. It is strike law that the making of an apology will mitigate the plaintiff's loss or damages. Court-ordered remedies remain an unconventional remedy in Hong Kong. In particular, the application of this remedy against an unwilling defendant in defamation cases has yet to be considered by the higher courts in Hong Kong. In Malaysia, we have had the higher courts look at this. Okay. In Hong Kong, there has been the development of statutory torts. There is the Disability Discrimination Ordinance, which provides the apology as a remedy. And then there is the Sex Discrimination Ordinance, which provides for a remedy in Section 76(3)(a). In Mak Bing Yun and Ko Chun, the Court of Final Appeal observed in paragraph 34, this was a case under the Disability Discrimination Ordinance, that where a defendant voluntarily makes an apology at an early stage, it will usually mitigate the plaintiff's loss. And the earlier it is made, the stronger will be its mitigating effect. In Ma Bing Yung, the situation did not arise, but the court did consider the situation of a defendant unwilling to comply with an apology order. There the court said an unwilling defendant should not be the subject of an apology order. Okay, in Hong Kong, since 1st December 2017, there has also come into force Hong Kong's apology ordinance. Okay, the apology ordinance clarifies the legal consequences of a person making an apology by affirming that it will generally not be admissible in evidence. That means to say that if you apologize, that will not be an admission of guilt. Okay. The apology is defined in Section 3 as an expression of the person's regret, sympathy, or benevolence in connection with the matter. Such an apology can be tendered in orally or by writing or by conduct. Now, while as we shall see, the apology is a relatively new phenomenon in Malaysia and Hong Kong, its jurisdictional basis has been canvassed in New South Wales and in New Zealand. I'm going to run very quickly to two cases, one from New South Wales and one from England. Okay. The New South Wales case is Summertime Holdings Proprietorship Limited and the Environmental Defenders Office Limited and others. What happened in this case was that the plaintiff sued the first, second, third, and fourth defendants in defamation for remarks made by the third defendant who was an employee of the first in a radio broadcast. Okay. So these remarks were said to be defamatory. The two parties then entered into correspondence and they got to the point where they drafted a deed and agreed on the wording of the apology. Then there was a change of heart on the part of the defendants and they refused to go through with the apology. They had agreed in the deed that the apology would be published in 2 newspapers and be broadcast over the radio, but they reneged on that. Now, the plaintiffs then applied for an order to compel the defendants to carry out the promise to apologize and to apologize in the terms agreed between the parties in the deed. The trial court, Justice Young, ruled on the evidence that the defendants had agreed to apologize to the plaintiffs in 2 newspapers and a broadcast over the radio. But his lordship held that only in an exceptional case would the court exercise its discretion to order an apology. Young J. explained that, and I quote, as a general rule, courts of equity do not become involved in defamation proceedings. This, he said, is not an absolute rule, nor is the statement I have just made completely true, but generally speaking, it is. Courts of equity, continued, do become involved every so often in very clear cases in making injunctions against defamatory statements. If I remember correctly, his lordship then referred to the fact that the action in defamation went into the Star Chamber in Britain, and by the time it emerged, he could not find a single case in which there had been an apology. I do not disagree with his lordship. I had no access to that material, but that's what his lordship said. Justice Young further held that when a party reneges on a promise to apologize for a defamatory statement, the damage that would be awarded would be not on the basis of the original defamatory statements, but for breach of the promise to apologize. His Lordship then went on to award damages in the sum of 10,000 against the first three defendants. The fourth successfully argued he should not be liable. Costs were also awarded against the first three defendants on joint and several bases. Justice Young ended his judgment by saying, this judgment is not to be entered for 7 days after hand down these reasons for judgment. If within those 7 days, the plaintiff and the first three defendants agree that after all, suitable apologies will be published and the deeds are exchanged, then I'm prepared to vacate the order for damages, leaving only the order for costs. Ultimately then, Justice Young was prepared to allow the parties to settle their differences, not by a court order, but by a compromise. And that, I may note, has always been the policy of the law, that parties should not litigate, but should compromise. Now, the strongest case that was made, that to my knowledge has been made for the award of apology order is in the New Zealand case of TV3 Network and Everyday New Zealand Limited.
5 minutes.
Okay, I told I have 5 minutes. In TV3, in this case, the plaintiffs were the importers and distributors of everyday products. Not everyday, ever-ready products.
3 minutes. 3 minutes.
They sued the appellants for broadcasting a 16-minute documentary in which they were identified as the importers of the products, and they claimed that the documentary contained false, malicious, and defamatory remarks about their products to the damage of their reputation in the sales. They claim, among other relief, a mandatory injunction directing the defendants to broadcast corrective advertising in forms similar to the broadcast complained of. At first instance, their prayer for the mandatory injunction was struck off, but later judge overruled the master who ordered the striking out and gave leave to the plaintiffs to appeal. The matter went up to the Court of Appeal, and at the Court of Appeal, Justice President Cook noted that all members of the quorum were of the view that the court had the jurisdiction requiring corrective advertising. Justice Cook held that the action for defamation developed in common law as attracting a remedy only in damages. That did not, his lordship noted, prevent the use of injunctions to restrain the threatened republication of defamatory publications after the passing of the Judicature Acts. In principle, there was no jurisdictional bar to the grant of a mandatory injunction. The remedy of injunction should be available when required by justice. Justice Cook said the court should be slow to grant the remedy, but the absence of authority and the assumption that the remedy did not exist could not establish the absence of the jurisdiction. So his lordship and the court then went ahead and awarded the mandatory injunction and the apology order. I'm going to skip the next slide. Now I come to Hong Kong. In Hong Kong, it has recently been recognized in Wave Chow that the Hong Kong court has a jurisdiction to make apology orders when it considers it just or convenient. However, in this case, it was a district court decision. Although the court said it had the jurisdiction, it decided not to issue the order. The decision was made under the district court ordinance and not under section 16 of the High Court ordinance. That might be an academic quibble. I'll leave it at that. In Malaysia, the higher courts, the award of remedy of apology orders has been considered by the superior courts, but usually it is on appeal. It has usually been on appeal from the High Court. Okay. So in dealing with these orders, the superior courts have reaffirmed that the courts have the jurisdiction to issue apology orders, but then it has gone on also to issue guidelines for the lower courts. So one of the cases where the court did this was the Credit Guarantee Corporation of Malaysia and against SSN Medical Products in Durian Berhad. Okay, the Court of Appeal in this case said that the court had the jurisdiction to issue an apology order, but then went on to emphasize that only in exceptional cases would an order for apology be favorably considered by the court, and the court referred to the authority of TV3 Network and Summertime Holdings. His Lordship, this is Justice Harminder Singh, also issued other guidelines, and I reproduced them on the next slide. He said, as with other remedies in defamation, the scope of the apology must be in proportion to the defamation. The order to publish an apology in a local newspaper is out of proportion where the defamatory remarks were circulated to a few subscribers to a financial service. Then he said, Lordship emphasized, no unwilling defendant should be subject to an apology order, and he specifically said that such an apology is useless.
Abdul, you have 1 minute remaining, if I can just remind you. Thank you.
1 minute? Okay, thank you. I'll just refer to this slide. Masita binti Muhammad Hassan and Sakina binti Sulong. This is the latest case in which the High Court has ordered an apology. Okay. The reason for putting this up is that the judge issued the apology order, but he grounded it in the wrong rules of court. He ordered it in Order 45, Rule 5, which deals with procedure rather than the jurisdiction to order this apology. So this is Order 50. This is the last case. Now my concluding remarks. This short excursion in the apology in defamation is not addressed what I call the elephant in the room. The elephant is defined by the following unanswered questions. Must the plaintiff pray for an apology order, or may the court issue an apology order on its own volition? This was done in Masita binti Muhammad Hassan against Sakina, the case I just referred to. And number two, is the apology to be ordered in addition to or in substitution of the normal order for damages? Perhaps future cases will answer these questions. Thank you.
Thank you very much, Abdul. We'll stick with the program, and we won't consider or take any questions on your presentation now, but we'll move to the next presentation. And this one will be presented by Professor Michael Fisher from Chinese University, Hong Kong Law. And the title of Michael's topic is A Tort Risen from the Grave, but to what effect? The Strange Case of the Rule in Wilkinson and Downton. Mick, take it away.
Mute.
Mick is muted. There we are.
I don't think I'm muted now.
And you're not. Now you're fine. Thanks, Mick.
Yeah, that's good. Okay. So over the course of the past few hours, we've heard a lot of very dense academic material. So I'm here as it were, the light relief. So I'm looking here at a largely, can I just try and make this slide a little bit narrower? Okay. A rather resurrected talk in the light of recent developments, one that had more or less lain fallow. And I want to consider at the end its implications as a possible remedy for our lack or arguable lack of harassment law in Hong Kong. Rick Lachesky has, of course, written about this, and Professor Witzleb will continue the theme thereafter. So I'm kind of setting the scene for him. Okay, so let's start with the seminal case, Wilkinson and Downton. Pretty much everyone here, I'm sure, knows it very well. It involves a practical joke that worked, but it worked rather too well. Now, the plaintiff, Mrs. Wilkinson, and her husband, Thomas, were publicans. They ran a pub, and Mr. Wilkinson went off for the day to the races, telling his wife he would travel back later on the train. So she, bless her, looked after the house on her own while he's away. But as all cynical Englishmen know, no good deed ever goes unpunished. And so it proved in this case, because later that night, the defendant Downton, who'd actually been at the races with Mr. Wilkinson, arrived at the house 10 o'clock at night, or what one of my colleagues used to call 10 p.m. at night, and told Mrs. Wilkinson, your husband changed his plans. He didn't actually decide to come home on the train. He tried to get instead to come back on a horse-drawn vehicle, which had an accident. He is now lying seriously injured with both his legs broken at a pub called The Elms. And he wants you to come there, send help, bring cushions, etc. So, not unnaturally, Mrs. Wilkinson was very distressed at the news. She sent her son and someone else to The Elms to find Mr. Wilkinson supposedly lying in pain. They soon found out, however, when they got there, that Downton had perpetrated a practical joke in very poor taste. Later that night, Mr. Wilkinson arrived home unscathed on the train, as he'd always intended. But by now, the damage had been done. Mrs. Wilkins successfully sued Downton for the psychological harm which had been caused to her by the incident. There were a few minor additional damages claims for the cost of the fare to get to the Elms, for Mr. Wilkinson's loss of consortium, that very sexist right that has long been abolished. But the ratio of the case in relation to Mrs. Wilkinson's loss was as follows, as explained by Justice Wright. He said, the defendant has, as I assume for the moment, willfully done an act calculated to cause physical harm to the plaintiff. That is to say, to infringe her right to personal safety, and has in fact thereby caused physical harm to her. Now, this word calculated has caused enormous controversy. Did he mean intend? Did he mean imputedly intend? Was he just careless? Should he have foreseen the obvious consequence or likely consequence of his foolishness, etc.? We'll look at that a bit later. Given, however, that at the time there was a reluctance to allow recovery of damages for mere psychological harm, Justice Wright created quite simply a new tort. We can't go in negligence because, as the law stands, the only case of significance, a Privy Council case, Victoria Railway and Cooltest, said no recovery for purely psychological harm. He says, that doesn't apply to intentional torts. And this is a tort of intention, which I've created. So the new tort is a hybrid. There are elements of trespass. After all, the act is intentional. Yes, the consequences may not be intended, but the act was certainly intentional. You told the person the story, indeed, you intended to upset her. I believe that Lord Neuberger has expressed that same view. What he didn't, no doubt, intend that she would actually suffer a recognized psychiatric injury. So, trespass, it was intentional, but also elements of negligence. The harm can be indirect, and as we know, trespass requires directness, and proof of loss is needed. Of course, trespass is actionable per se. So what's the significance of the case? Justice Wright's ratio provided scope, at least for academics, to solve the lacuna in respect of indirect harm caused by an intentional act, which in light of Lord Denning's exposition in Latang and Cooper could be neither trespass, because it wasn't sufficiently direct, nor arguably, given the element of intent, negligence. Now, quickly, I'm sure you all know this, but in Latang and Cooper, Lord Denning said the old forms of action notions that what's important is the harm direct, in which case the appropriate tort is trespass, or is it indirect? Then the appropriate tort is case, or as we now say, negligence. What Denning believed is that we should replace this with the mental element. What matters is, did you intend to harm? In this case, it's trespass. If not, if you were careless and you owed a duty of care, then the appropriate tort would be negligence. Consistently, what Lord Denning should then have defined is trespass, trespass as a tort simply of intention. But he went on to say intentional and direct. So what about those harms which are caused indirectly, but clearly intentionally? So, absent directness and innocence of harm, the rule might operate where trespass could not. And indeed, a quote from Mark Lunny and Oliphant, any successful action for assault requires the claimant to apprehend a direct and immediate application of force to his or her person. So we don't have directness in this case, so we can't have trespass. So for years after Latang and Cooper, examiners loved. Now I know Rick Lovchesky believes in setting real case situations in his examinations, but most of us don't do this. And so for years, no trespass to the person exam question, I confess I still do this, was complete without a rope tied at the top of the stairs with the intention that the plaintiff was going to come along later and trip over it, or a pit would be dug in his normal route home so that he would fall down it, or a glass of wine would be spiked with a drug, a sleeping pill, or poisoned. And in most of these cases, the drug victim later woke up in an accidentally locked room, so you then invoked false imprisonment as well. Judicial decisions, on the other hand, in civil and criminal cases, tended to be less fastidious about the need for directness in assault and battery actions. Turning to the courts then, academic niceties were largely ignored by the English judges, who continued the Scott and Shepherd tradition. In that case, of course, before there ever really was a proper law of negligence, involved a firework, a squib being thrown into a crowd and then, oh my God, picked up and thrown on, and eventually hitting the plaintiff. It was held that this was sufficiently direct to constitute trespass. Some of us may say it doesn't seem very direct. I believe Professor Kluczewski has even raised the possibility of, couldn't this be a transferred malice case? But suffice to say that the courts weren't overly concerned about this directness. The later case, DPP and K, found sufficient directness for a criminal prosecution under Section 47, the Offences Against the Person Act, when a student carrying out a sort of experiment deliberately put sulfuric acid in a hand dryer, panicking because he thought he was going to be discovered. He put it there, and a little bit later, a fellow pupil tried to put on the hand dryer. This acid splashed into his face, and he was badly burned. It was held that this was indeed a criminal trespass, though we might surely argue that this was hardly direct. Again, in a case called Ireland, telephone threats, or rather actually menacing telephone silences, were held to be a trespass. Though again, imminence seems to have been lacking. I believe that Street rather questions this. You know, it could only surely be a trespass if the person making the silent phone call was sitting outside and calling you from his mobile, so that the threats might seem to have the necessary imminence, otherwise not. Again, the courts have been less concerned about our academic reservations. So, Hong Kong courts have followed that line. In Wong Wai Hing and Hoi Wei Lee, Justice Sakrani said, threats which put a reasonable person in fear or apprehension of physical violence can constitute an assault, i.e. a reasonable apprehension of a battery, although the victim did not know when that physical violence may be effective. So again, as tort lawyers, we say that assault requires apprehension of immediate or very soon physical contact. And yet here, Socrates says, applying an Australian case that we deal with in contract, a duress case. If you don't make this contract with me, I'll have you killed. Again, quoting that, Socrates said, this can be an assault. Now, what about post-Wilkinson jurisprudence? Only one case of significance before a long hiatus. And this case was Janvier and Sweeney, or Janvier and Sweeney, probably correctly, which eventually went to the Court of Appeal. And it was also concerned with a statement, though I think we'd agree a far more sinister one. So in Janvier, the case involved circumstances which arose during World War I. The plaintiff, Mademoiselle Janvier, was a French paid companion in London. Her lover was a German man interned as an enemy agent with whom she corresponded by letter. So she, in short, her crime was she had a German boyfriend. The defendant was a private detective who wanted access, not to the plaintiff's, but the plaintiff's employer's papers. So he sent his assistants to get basically entrance. They posed as policemen to gain entry and said that the plaintiff, Miss Janvier, was suspected of spying. Now, of course, at the time, the spies were shot. This was wartime. And they did this solely to get access to the house. The plaintiff suffered severe nervous shock as a result and was awarded £250 by a jury, upheld on appeal. Again, Wilkinson and Downton applied. Subsequent to Janvier, there was relative inertia. In the case of Opio and Rhodes, Lady Hale said, there appear to be no reported cases on the rule in Wilkinson and Downton for the next 70 years after Janvier. In the last 25 years, it's had a modest resurgence in the context of harassment, which is where we came in, as it were. So the rule was invoked, somewhat peripherally in Coruscant and Bush, to support the imposition of injunction against a spurned boyfriend. Prime rationale for the decision in that case was nuisance, though that's now regarded as wrong, certainly by Lord Hoffman, who insists that nuisance is a property tort. And Miss Coruscant didn't qualify, A, because she had no proprietary interest, she was a mere licensee in the premises, and B, because she didn't suffer any interference with her enjoyment of land, merely with her, as it were, peace and quietude. The rule was also pleaded unsuccessfully in Wong and Parkside Health Trust, involving harassment at work, and Wainwright and the Home Office, which involved post-traumatic stress disorder caused by an unlawful strip search. The case did succeed before the European Court of Human Rights, but not before the English courts as such. Wong and similar cases are now dealt with almost certainly by legislation in the UK, the Protection from Harassment Act. But, and this again is the crux of our talks, no such legislation applies in Hong Kong. In Wainwright, Lord Hoffman felt that the rule was largely now irrelevant. Two reasons. Harassment cases were now provided for by statute, and indeed most of them, most of the cases we've looked at might well be so covered. In addition, traditional rule cases like Wilkinson and Janvier, he said, would now be subsumed by the tort of negligence. And this argument seems to be supported by Whitting Street, i.e. Christian Whitting's Street on Torts. Lord Hoffman's rationale was that the only reason that Justice Wright had to invoke the rule in Wilkinson and Downton was at the time there was no recovery possible for psychiatric harm caused in negligence, the Victoria Railway and Coultas principle. He says this is no longer an impediment, and therefore negligence would suffice. Now, his analysis was the subject of trenchant criticism in the next case, Rhodes. Quickly, to tell you what the criticism was, well, I share this view. Wilkinson and Downton surely would still not be decided on the basis of negligence, because surely Mrs. Wilkinson, concerned for her husband, was a secondary victim. And what about unaided senses? What about proximity in time and space? So I don't think she would. Janvier, maybe. Yes, an action in negligence, but I don't think it would have helped Mrs. Wilkinson. That's my view. Supreme Court in Rhodes also said that, you know, Justice Wright was wrong. Justice Wright could, if he wanted, have simply ignored Coultas because it was Privy Council. That, I think, is a little disingenuous. First instance judges don't very often like to depart from the Privy Council, given its status, despite the fact that in theory, in precedent terms, they could. The dominant case in the rule is now Rhodes. This case, said Lord Toulson, is a case about a book. It was indeed, but it was no ordinary book. The book, instrumental, a searing autobiography, one in which I'm very interested. I've made my students very interested. Some of them have even bought it. Instrumental is a very powerful autobiography written by a man severely damaged by appalling sexual abuse as a child and partially restored by the catharsis of music. To quote, "Music has quite literally saved my life, and I believe the lives of countless others. It's provided company where there is none, understanding where there is confusion, comfort where there is distress, and sheer unpolluted energy where there is a hollow shell of brokenness and fatigue." Very strong stuff, not as strong as his descriptions of what happened to him as a child. I'll omit these. I think they might disturb some. But suffice to say, it is a graphic account of sexual abuse from the age of 6 years old at the hands of a boxing coach, Mr. Lee. Now, the issues. The English court had, the UK court eventually, of course, had the difficult task of balancing James Rhodes's right to tell his own story in his own way with his ex-wife's attempts to stop or at least edit publication to protect their autistic son, now living in America, from exposure to the terrible details of his father's tragic early life. Now, this is a case I got very interested about, first read about in the satirical magazine Private Eye, which simply said, here's a case where someone is dredging up an obsolete old tort to try to stop freedom of expression. I think the case is far more nuanced than this. One can see her point. The book is dedicated to James Rhodes's son, and if that poor autistic child did read the book, he may very well be disturbed, upset, distressed, maybe worse. On the other hand, we have freedom of expression and James Rhodes's right to tell his story in his own way. In the Court of Appeal, a temporary injunction was confirmed, leading judgment by Lady Justice Arden. One factor to take in mind was that when the parties divorced, tragically, but the marriage was, as it were, irretrievably destroyed by his previous experiences, his self-harm, his suicide, etc. Lady Justice Arden may have been influenced by the fact that in the separation, the divorce agreement, they did actually promise that nothing published by the parties would affect their son's well-being. So, question mark.
Mick, I'm going to just remind you now or inform you that you have about 1 minute remaining.
Okay. In so doing, then, the court affirmed the rule in Wilkinson and Downton. The new formulation, words or conduct aimed at the plaintiff without justification or reasonable excuse, an intention to cause physical harm or severe mental or emotional distress, resulting physical harm or recognized psychiatric illness. This was applied in Rhodes. They said very clearly there was no intention to harm and there was every justification in publication. Intention is different from calculated. But, said the Supreme Court, we are now going to replace the word calculated with a very clear word, intention, and the intention must be to cause either physical injury or serious psychological harm. And in Wong and Parkside, Lady Justice Hale, as she then was, said in Wilkinson and Downton, the defendant did not intend to cause physical harm to the plaintiff. But even if Downton did not intend to cause, does this necessarily mean that Wilkinson is no longer good law? Lord Neuberger said, the fact that a statement is intended to be a joke is not inconsistent with the notion that he intended to upset. I would simply put it like this. If that joke had not upset Mrs. Wilkinson, it wouldn't have worked. If she'd said, you're just pulling my leg, it would have been a hopeless practical joke. So it was intended to upset, but not as extremely, or not to produce serious mental injury. As far as UK is concerned, Wilkinson and Downton will be rarely applied. Legislation covers it, harassment covers it in most cases. It was applied in a case called ABC and Westheath, another abuse case, a sort of abuse case, grooming of a child, and a case strange in that the groomer, a teacher at a school, was held liable for this under Wilkinson and Downton. The school was held vicariously liable, but insisted, as is their right, on 100% contribution from the actual tortfeasor. So what about Hong Kong? Harassment will probably suffice in the UK, and so will the extent, or alternatively, the extended negligence rules. But what about Hong Kong? We've got a problem in Hong Kong with harassment. It involves either, as is more often in the English case, spurned lovers, but more importantly for us, debt collection agencies who call you in the middle of the night, who make implicit threats to do something whenever we don't know, etc. My suggestion is that the use creatively of Wilkinson and Downton could solve the problem. Rick Lofczewski, I've mentioned, says essentially, it's no way to say that our judges can simply create a tort of harassment. His preferred option is legislation. I would suggest that legislation of this sort is not, as it were, at the head of our legislature's priorities. So could we develop Wilkinson and Downton? We could certainly apply this to a typical harassment, unjustified act or statement, no problem there. Directed at the plaintiff, no doubt. An intention to cause physical harm or serious upset or distress, tick that box too. What we don't have is resulting psychiatric harm. And what I would suggest is we would simply do away with that. Lord Newberg in Rhodes clearly felt that this may be a problem. And let me just finish with his quote. There's plainly a powerful case for saying that in relation to the instant tort, liability for distressing statements should be enough for the claimant to establish that he suffered a significant distress. It's not entirely easy to see why, if an intention to cause distress is an ingredient of the tort and is enough to establish the tort in principle, the claimant should have to establish that he suffered something more serious in the form of a recognized psychiatric injury. In other words, under Rhodes, the mental element needed is inconsistent with the harm element. You only need to severely distress mentally, but you must actually cause physical harm or a recognized psychiatric injury. If we did away with that third requirement in Hong Kong, we, I suggest, have a solution to many of our harassment problems. And I better leave it there. Suffice to say, I paved the way, like John the Baptist, for Professor Witzlev, who will demonstrate more efficacious ways, I have no doubt, to deal with the issue of harassment in Hong Kong. Thank you.
Thank you very much, Mick. And we'll wait or defer any questions that may be pose to you until after all of the speakers have completed. I want to remind all of the participants that if they wish to pose a question to any of the speakers, please do so through the chat box. So let's go now to our next speaker, who is really also to be congratulated and to be thanked for being the host of this conference and putting it on in such a professional and efficient way. The next speaker being Professor Norman Witzleb of COHK Law. He now will speak to us on a related topic, very closely related to mix, a tort of harassment for Hong Kong, evaluating options for reform. Norm, go ahead, the floor is yours.
All right, thank you, Rick, for that kind introduction. Yes, well, I'll try and make my case now, on the back of what Mike has already said and how he has paved the way, So ultimately, I'm a proponent actually of legislative reform, and the way I propose to make my case is looking first at the law in Hong Kong as it currently stands, looking at the developments in overseas jurisdictions of the common law, in particular UK, New Zealand, Singapore, and if time permits, perhaps Australia as well, and then looking at what we can learn from the experiences overseas for the development of Hong Kong law. If we start with the current status of the law, so Mike has already suggested, that the courts in Hong Kong have developed at common law a tort of harassment. It took a while to get there, so the early cases around the 2000s generally denied the existence of a tort, usually relying on English cases that said there is no such tort. But from 2004 onwards, the Court of Appeal said in a case in Wong Tai Wai David that so that tort might exist, and refused to strike out a claim on the basis of that tort, and that paved the way for subsequent courts then to develop the law, recognize a tort, and so on. The leading case is no doubt the decision in Lau Tat Wai Yip Kai Lai Quen Joey. It's a decision at first instance, and it's based on very extreme circumstances, I would say. It's a case in which the defendant had known the plaintiff and basically had a romantic relationship with the plaintiff for a number of months, and then engaged in a 6-year campaign after the relationship ended of harassment, issuing threats against the plaintiff for his safety, for the safety of his family, and did a lot of disturbing things, that ultimately, required the plaintiff to maintain contact with the defendant against his will, made him lose his job, give up his home. So it had really severe emotional consequences for and other consequences for the plaintiff. The court had no doubt that a wrong was committed, so the defendant had to pay a substantial amount of damages under the torts of intimidation and the tort of harassment. The court defined the cause of action in harassment as conduct by a person, whether by words or by action, directly or through third parties, that is sufficiently repetitive in nature as it and would cause to the knowledge of the defendant that other person's distress or annoyance. The mental element of the tort is intention and recklessness, and the tort requires damage. But damage is basically widely defined as both economic loss and distress and humiliation. So this is the case that subsequent cases then built on and relied upon, and the majority of cases, there's really only one significant exception to that, then used this case and basically applied it because it contains I think the most comprehensive discussion and also exposition of the elements of the tort. I don't want to go into the various cases, that others have done that already. So I think, including Rick, of course, I don't need to perhaps go into a lot of detail there, but if you look at the cases here on the slide, you can see that, harassment claims can arise from a whole range of social context. It can be business dealings gone wrong. It can be sort of the ex-partner scenarios that Mike mentioned and that were the basis of the claim in Lauthard Y. And it can also be, the situation that's fairly common in Hong Kong of, debt collection through, through threats and other illegitimate means. Quite recently, harassment has also been used as a basis for an injunction in a case of doxing. So doxing is the use of personal information to intimidate or harm another person. So there is a decision of, again, the court of first instance in Secretary for Justice and Persons Unknown, that basically granted an injunction against the use of personal information, to intimidate police officers and their family, following the social unrest in Hong Kong in 2019. So a wide range of circumstances in which harassment has been claimed and has been used as a tort. But if you want to look at, whether the law is appropriate and sufficient as it stands, we probably need to have a look at wider, the wider parameters of the tort and the overall structure of the law. So, my suggestion, and I think it's builds also, or picks up on what Mike has already mentioned, is you need to look at, how the various torts actually hang together and how they, interact with one another. And actually, you need to also look beyond tort, beyond private law, into other legislation, and see whether taken together, the law provides adequate and sufficient redress to victims of harassment. If we look at other torts, so very often harassment claims are brought together with claims under the tort of intimidation. So that's actually also a fairly unique Hong Kong development, because intimidation is, has historically been conceptualized as an economic tort. The idea is that someone, makes a threat coupled with a demand, and the plaintiff responds or basically gives into that demand and does something that they wouldn't otherwise do, thereby causing themselves harm. So the harm usually is economic harm. But Hong Kong courts have, expanded intimidation and turned it in a tort that is ultimately concerned with intentional unlawful coercion. So there's no need for a plaintiff to actually have given into a threat and to have suffered economic harm. It's enough that they've been exposed to the threat, so that there was an attempt of coercion of their will, and the damage can also consist in emotional distress ultimately, which creates a large degree of overlap between this tort and harassment tort. Mike's suggestion, was that, or basically rightly observed, that there's also this close link between intentional infliction of harm and harassment. That's true, because they're both concerned with intentional conduct, that is causing distress. But if you understand OPO and Rhodes right, then basically the court insisted on the damage element of that tort being personal injury, either physical injury or psychiatric harm, and on that basis, currently as the tort stands, the overlap with harassment is actually quite small. So if we remove that requirement, then of course, the two torts would coincide to a much larger degree. If you look at the law outside tort, so where can harassment victims turn to? In one sense, where harassment is based on discrimination on the basis of sex, disability, or race, anti-discrimination ordinances come to assistance, because they don't only prohibit discrimination, but also harassment following from it. They create statutory torts, that allow for orders and for injunctions and damages. The ordinances have quite a wide definition of harassment, so it's unwelcome conduct that causes distress and the like. But they're actually quite limited in the scope of application because they largely deal with workplace relations, the workplace context or the provision of public services, but not really so much interpersonal relations. Another ordinance that can come into play is the Domestic and Cohabitation Relationships Violence Ordinance, but as the name suggests, that only applies in the context of domestic violence cases, again, not more broadly. There have been attempts, to introduce a stalking offense in Hong Kong. Those offenses have stalled quite a long time ago. The Law Reform Commission suggested a stalking offense, or basically a harassment offense, actually, to combat stalking and related behavior in the year 2000. In 2011, there was another attempt to resurrect that proposal, but it hasn't been implemented. But there is actually some unfinished business in that area because most other comparable jurisdictions have a stalking offense and actually provide stronger criminal protections of I think the particular harmful forms of stalking and harassment. Where we have seen some recent reforms is in the context of doxing. Last year, the Personal Data Privacy Ordinance has been amended to create an offense of doxing. So we've seen there was already basically use of the common law to create injunctions where that conduct occurs, but now we actually have a criminal offense as well. But the legislation is really quite piecemeal, imperfect, in response, perhaps not in a holistic and comprehensive way to, I guess, the phenomena that taken together make up, harassment and stalking behavior. So if we try and summarize the law in Hong Kong as it currently stands, what we would have to say is that harassment can occur in quite a wide range of fact scenarios, and it does occur. It's serious behavior that can have dramatic consequences for plaintiffs. The law gets by, with an harassment tort, that has recognition on the basis of first instance decision. No appellate court has, recognized or confirmed that tort. And because there's not that many cases, also the elements and the defenses and the remedies of the cause of action aren't fully defined. And as I've just mentioned, the relationship with other torts, with other pieces of legislation are also, somewhat underdeveloped and would need some looking into to, basically, I guess, to have to beef up and to have more robust protections against harassment. The courts in Hong Kong looked at what happened in other jurisdictions. The problem is that, most other jurisdictions have moved on from protections that perhaps might have existed at common law to statutory enactments against harassment. So it's not easy for Hong Kong courts to then draw on foreign jurisprudence because the jurisprudential basis is just a different one. What I propose to do now is just have a brief look at the enactments in like a number of the jurisdictions in question, starting with the UK. The UK has a Protection from Harassment Act since, for I think it's 25 years, so it's the silver jubilee in other words. Initially, it was enacted to deal with stalking behaviors, but actually encompasses also other behaviors. It requires repetitive behavior, which is at least, conduct on 2 occasions. That has subsequently been somewhat amended, and where behavior affects 2 or more people or is engaged in by 2 or more people. The Act doesn't really define harassment other than to say it includes conduct that alarms a person or causes a person distress. The courts have built on that and have basically required a certain gravity of the conduct. They say it must be a persistent and deliberate cause of unreasonable and oppressive conduct. So not just anything that alarms or distresses a person. There's a criminal offense and there is civil wrongs. Civil wrongs can be pursued in court in order to gain a non-harassment order or to gain damages. There are defenses in the Act, but the courts also make clear that where harassment consists of speech, freedom of speech is to be weighed in the balance before an order is made. So that basically, if you look at the Act overall, the courts have, basically used it as a basis to obtain a relatively finely balanced and nuanced approach to dealing with cases of harassment now. If you're looking at New Zealand, the New Zealand Act is as old as the Act in the UK. It has a number of similarities with the UK Act. Again, that there's a pattern of behavior required, on the 2 or more occasions, and again that the legislation subsequently, softened up on it and said, well, when behavior has a protracted effect, then a single action is sufficient, and that it has a criminal offense and civil liability that is a commonality as well. But then there's also some differences. One difference is that it actually defines what amounts to harassing behavior. So it lists certain forms of conduct, watching, loitering, interfering with property and the like, or other things that make someone fear for their safety. That's quite a high threshold. Fearing for their safety is higher than the threshold, certainly in Hong Kong, and probably also in the UK. Another point of difference is that under the Act, you can only gain a restraining order, but you can't get damages. If you want to get damages, you need to go to the general law protections. But New Zealand has a privacy tort that might apply, or other of the general tort actions, depending on the circumstances. The Harassment Act is, basically in a way subsidiary to the Family Violence Act in New Zealand. So if there's family violence, then you have to go to that act rather than to the more general Harassment Act. And New Zealand has also fairly advanced and progressive legislation against harmful digital communications, allowing someone to basically proceed and to gain orders under that enactment as well. If you look at if you look at Singapore, Singapore enacted a Protection from Harassment Act in 2014. It again has shares some similarities and commonalities with the other acts. One difference is that it doesn't have 1 or 2 offenses, but 5. So it's quite detailed, and again, it lists the what amounts to those defenses in some detail. It doesn't really define the behaviors, but it makes use of statutory examples of what fits the various offense provisions. In 2019, the Singapore Act also adopted an amendment that is ultimately an anti-doxing offense, so that publishing identity information with the intention to cause violence and or other harm is punishable. Most of the offenses are statutory torts, which means that you can gain a court order or gain damages if the conduct has already occurred and caused injury to the plaintiff. One interesting innovation in Singapore is that in 2021, an amendment created a Protection from Harassment Court, which offers a simplified, speedier, and basically more effective procedure for someone who wants to get judicial protection. That is ultimately something that is worth looking at, that it's not only the substantive law that's important, but it's also access to justice that needs to be considered, and that specific legislation often can improve upon. Australia doesn't have that much to add. Rick, how much time do I still have?
Now, Norman, your time is almost up. Can I put it that way?
Oh, okay, that was quick, but I'll
almost up. So you can
okay.
continue.
So basically, Australia doesn't really have much to offer. Even though I'd like to talk about Australia, but not in this case. There's no harassment tort, neither at common law nor in the statute. They largely rely on criminal law.
Take a minute or two, Norman.
Sorry?
Take a minute or two if you like. Take 1 or 2 minutes. We have luxury of a little bit of time.
So what are the options for Hong Kong? Well, one option, of course, is to leave matters where they are. So we've got a functioning common law tort. I think it's not the ideal way, because, well, the tort is uncertain in its status, it's uncertain in its scope. So it would be preferable to have legislative reform. It would provide better signaling, that harassment behaviors are wrongful, would have clearer, more targeted definitions. It would be able to criminalize the most harmful forms of harassment. And it would also, basically provide a basis for creating sufficient balances in the act, so that basically, reasonable conduct or conduct that is for one or other reason justified is not ultimately penalized or exposes the defendant to liability. I think it's important also, that all the other jurisdictions that introduce legislation have broadened the array of remedies, have looked into when restraining orders and the like are available, and looked at the, basically the process of obtaining those orders and facilitated that in order to improve protections. The other thing that's important is, so there is in Hong Kong, I think, a backlog of work to be done to protect against harmful communications more broadly. So we've got some criminal law reforms on intimate image abuse, on doxing, but they really are quite piecemeal, and they haven't really looked at, the whole array of hurtful or harmful communications more broadly. The stalking legislation, as I mentioned, is not in place. Domestic violence legislation, I think, is also behind the times. So there's actually a need to look at this area more holistically. And if you do that, then perhaps also there would be a chance to look at, missing, legislation or development of a tort of privacy. So that would be my case for statutory law reform, but of course I share some of Mike's concern that this might not be particularly high on the agenda, but it's important, I think, to put it on the table as something that ought to occur, and we'll have to see, whether that, falls on fertile ground.
Well, thank you very much, Norman. And thank you to all of the speakers. What you've just touched on, Norman, and what Mick has mentioned as well, regarding whether this kind of reform is high on the agenda with the Hong Kong legislature, that's an open question. One can look back and see that there has been really no tort law reform done in a by way of statutory intervention for decades. And one may well wonder what it takes to move the legislature in these kinds of important areas, and that may be that, who knows, that may change. I have my own views on why there has been a drought and then why there may not be, but I won't express them right now. So thank you, Norman, and all of the speakers. I now, as I observe that the chat box, if I am reading or opening the chat box correctly, it seems that there are no questions raised by members of the audience. Now, this can be understood as good news. Not only does it perhaps mean that we will have a longer break, but also that the presentations were very clear and did not trigger any doubts or questions by the members of the audience. But so I'll do what a previous chair has done, and I think that was you, Norman, and that is invite the speakers to pose questions to each other if you like. But in the meantime, if I may, I have 1 or 2 general questions, which I will maybe pose. first, and then if other questions come from the chat box, I will give way to those, if that's all right. And I'm grateful for the invitation to participate in this conference, but in this session as a chair, because these topics are of interest to me and are quite helpful actually in identifying some case law that I wasn't fully aware of that would probably help in the writing of the 5th edition of my tort book. So I wonder, Mick, if I can pose a question to you having to do with the Rhodes case. What, in your view, is the likely impact of Rhodes on the development of the Wilkinson and Downton tort in Hong Kong? In certain areas of tort law and in the law generally, the Hong Kong courts tend to follow where it is convenient to do so, a leading House of Lords or Supreme Court case. And I wonder if that should be the case here, given that we, by comparison to the UK, have had a flourishing history of Wilkinson and Downton cases.
Yeah, I did suggest I don't think it's going to have a huge impact as far as the UK is concerned, and likewise Hong Kong, unless, you know, and that's the key, unless we remove the harm element, or to make the harm element, as it were, consistent with the mental element. If you commit the tort by words or acts with the intention of upsetting or distressing someone, then why should the harm element be more extreme than that? Why is it not enough, quite simply, to say, and if in the process you do cause severe distress to somebody, you'll be liable? If we did that, I think we would have cracked a lot of the spurned lover and indeed debt collection problems.
So you see a future for the Wilkinson and Downton tort in Hong Kong, perhaps because we don't have harassment legislation, or how would you?
Realistically, I think it's more likely that our courts will continue to insist that, for most of them anyway, to insist that there is a tort of harassment, and therefore there's no call for that. But I know that that's not your preferred option, and it is a problem. I mean, if we say there is no tort of harassment at common law, as Brenda Hale did, and there's no legislation in Hong Kong, where does this tort actually come from?
Right. Thanks, Mick. That's a question that I was just about to ask of Norman, because I am sort of, I have been puzzled by the suggestion that the tort exists. We see this in the case law that you have both, or that in particular Norman has outlined, and yet I wonder, how can it come about as a creation of the courts of first instance? Would it not require something more? And I think you may have read my argument before, that if the English judges have stated that there was no tort of harassment, and that's why we have to introduce legislation, then in Hong Kong, where does it come from?
Yeah, well, I mean, it's a common law method, to develop new torts, by granting remedies to someone who comes to the court and says, this is what happened to me, and the court providing a remedy, that's how they create a tort. I mean, the Wilkinson and Downton tort wasn't a tort that was recognized at the highest, at the highest level of the highest courts. I don't think it's a requirement, that it's basically gets the stamp of approval by the highest court, or that can only originate from the highest court, but as long as it's only in the lower courts, there's always that cloud over the tort, that it might get, the Court of Appeal might come along and say, well, the lower courts have done it wrong for the longest period of time, So I don't think it's the case in Hong Kong, and there's there's been a period in Australia where the High Court said, if there's supposed to be new law, then it's us who makes that. You know, so, but I think in the position in Hong Kong is like in other common law jurisdictions, is the courts can create new cause of action, new torts, and it can start probably at lower courts, you know, as long as they don't basically, you know, I think, you know, do something that is against, you know, the judgments of higher courts. You know, I think, you know, they can fill gaps in the law.
Yes, I suppose so. I was thinking that if it were to happen that way, in the way that you've described, then it would be done so openly as by the court as to, you know, what the genesis of this tort is, why we should introduce it. But the statements made, I think, by the judges are more along the lines that there is a tort of harassment in Hong Kong, and that being the case, and that's why I raised the question that then there is, okay, but where is the evidence of it? But anyway, thanks. You want to add to that, or maybe you've answered my question already. Anything from either Mike or Mick or Norman? Abdul has a question. I have a question for Abdul too, but Abdul, raise your question if you like. You'll have to unmute yourself.
A comment on the thought that you're talking about, that it has been revived and is live and kicking in Canadian jurisprudence. The Malaysian Court of Appeal was trying to decide whether there should be a tort of sexual harassment. And the Court of Appeal then decided it didn't want to recognize the tort of sexual harassment. Instead, it recognized the tort based on Downton. What are the parties? Downton and Wilkinson. It went down that road and we recognized that, then went up to the federal court, which set the Court of Appeal right and said, no, there is sexual harassment. So we recognize the tort of sexual harassment at common law. But before that, we had a side excursion into this.
Thank you, Abdul. While I have you there, Abdul,
yes.
I wanted to ask your view on on your last slide. I believe you raised a question, or identified a question raised by the court, and you speculated what would be the future direction about the role of apology in the context of an award for damages. Would it be one or the other? But that went unanswered by the court, I presume, or on your slide. But could you just amplify on that point a little bit? I'm curious about whether you contemplate an order, both orders being made at the same time, or whether the apology would be used as a means of dealing with a case, providing some sort of answer for the plaintiff without having to award damages. How do you see that?
Okay, what has happened is that there are a number of cases decided by the High Court, it's equivalent of the Court of First Instance, in which the parties by consent agree to settle for an apology from the defendant. I tried my best to get this. I get the stories, but nobody's willing to give me a citation. This were the parties and this was the case. So I've had so far one citation, but that is by compromise, not by court order. Now, on where the court order is concerned, so far, it seems to me that it's a court which orders the apology. And I'm thinking this to myself, that when you file for remedies, you have a list of prayers and you usually have one which says any further and other relief as this honorable court might deem justified. Would the court act under that, or would the court move to say you must pray specifically for damages and for an apology? I don't know which way it will go. I don't have an answer.
Thank you very much, Abdul. Thank you again, all of the speakers. I think we can close the session.